Good morning, and welcome to today's episode of Legally Not Red, Legally Raven Hair. My hair is up today because I washed it and let it air dry last night. So we'll see how that turns out. So we're going to continue to reading about the Schulansky Goes to Court chapter. We were supposed to read in chapter 30 of this, and I really wish I had the e-version of this book because I would really love to read this with it up on the screen. But anyway, so this is the drafting request. Memorandum. David E. Howard, Associate, from Phyllis Slater, regarding Schulansky construction dispute, our file number 04-1248, November 20th, 2004. Deborah Schulansky, a client of ours, has consulted me concerning a dispute that has arisen between her and a contractor who recently built an addition to her vacation home. Big problems, addition to vacation home, okay? It appears that this problem cannot be resolved without filing suit. I would like you to help me with the case. Although Schulansky lives here in Plymouth, Massachusetts, she also owns an antique colonial home in Alton, New Hampshire, which she uses as a vacation home. The house dates from 1782 and is listed in the National Register of Historic Places. Last spring, Ms. Schulansky met Richard Ronan, a New Hampshire contractor, while he was restoring a house in Plymouth. After some negotiation at her home in Plymouth, the parties agreed that Ronan would build an addition on the back of the Alton house. Ronan mailed a proposal and estimate to Schulansky in Plymouth, and she signed and returned it. I have attached a copy of the proposal and estimate for the job signed by both parties. The work involved taking out part of the back wall of the house and building an 18-foot by 25-foot addition behind the living room with a full cellar under the addition. The contractor was to excavate the earth from the original foundation, excavate the adjacent area behind the living room with a full cellar under the addition. The contractor was to excavate the earth from the original foundation, excavate the adjacent area to be occupied by the addition, lay a cellar floor and foundation wall in the excavated area to support the addition, and build the addition above the new cellar area in order to provide access to the new cellar. The contractor must break a doorway through the original foundation of the main house adjacent to the addition. There were problems from the beginning of the construction work. Ronan hired a backhoe operator named Jones to do the excavation work, as he told Schulansky he would. When Jones excavated the earth from the original foundation with his backhoe, he discovered that the lower part of the foundation was simply loose rubble. Evidently, in colonial days, it was fairly common to simply pile large rocks around the perimeter of the house site and build brick and mortar foundations on top of the rocks. This rubble foundation apparently lasts remarkably well as long as left undisturbed, but are less stable if exposed, as was necessary here to construct the cellar for the new addition. Apparently, there was some discussion during the negotiations about possible problems with the old foundation. Schulansky asked Ronan if he anticipated any problems due to the service of the foundation. He responded that he doubted there would be any problems, but if anything were loose, he would do whatever was needed to provide adequate support for the addition. When Schulansky visited the site during construction and observed the excavation, she became concerned about the stability of the new foundation. For one thing, she could see that the foundation was just loose rubble with no mortar or other support except the surrounding earth. For another, the backhoe had repeatedly plowed into the old foundation in the course of excavating the new cellar, and loose rock from the foundation were laying in the ditch next to the foundation. Schulansky asked Ronan several times if the old foundation was adequate and asked him to reinforce or rebuild it. Ronan refused to do any major reconstruction on the ground that he had not agreed to do so and that it wasn't necessary. Instead, he simply poured some cement in between the rocks and left it at that. In May, when the job was virtually complete, Schulansky began to notice cracks in the plaster walls of the living room and the bedroom above it and in the addition itself. She also observed some sagging in the floor at the joint between the main house and the addition. She had a friend who was a structural engineer come and look at the house. Why didn't you call your friend who was a structural engineer before you let him continue? If you have a friend that's a structural engineer, why you didn't call him before you started? Because she asked if we were going to be a foundation, so clearly she was concerned. He concluded that the cracks resulted from the settling of the old foundation, evidently due to shifting of the rubble after exposure during excavation. He was unsure whether the settling resulted from negligent excavation, that is, the rubber being undisturbed by the backhoe, or from the removal of the supporting earth on the outside of the old foundation. In either case, his opinion is that the settling will continue causing major structural damage unless the foundation is rebuilt. Because the addition is not completed, that reconstruction will be substantially more expensive than it would have been if it had been done during construction to the addition. He estimates that it could cost as much as $25,000 to jack up the house and reconstruct the foundation, and another $80,000 to repair the damage to the house due to the settlement of the foundation. Schulansky has tried to work with Ronan, but he denies any responsibility. Consequently, she refused to make the final payment under the contract. I talked to Ronan myself and written him a demand letter, but it is clear that he will refuse to provide any satisfaction to our client and said he is certain to file suit himself if Schulansky does not pay him the last progress payment under the contract. I intend to initiate suit against Ronan personally and against Ronan Construction Company for breadth of contract and negligence. Although we could probably bring suit in federal court on the basis of diversity, Ronan lives in Nashua. Ronan Construction is incorporated in New Hampshire, and his principal place of business is probably in New Hampshire. I would prefer to litigate here in the Plymouth Superior Court. I realize that we may have a claim against Jones as well at the moment. However, I am not even sure of Jones's full name, much less where he lives. Whether he is insured or whether he is subject to personal jurisdiction here, we will have to learn more about Jones through discovery and amend to act if necessary. But I have some hope that this will be settled quickly without the expense of lengthy multi-party litigation. Please drop the complaint and summons to initiate this suit in the Superior Court of Plymouth County. If you need further information, talk to me or Ms. Schulansky directly. As you know, Rules 811 of the Massachusetts Rules of Civil Procedure are similar to Rules 811 of the Federal Rules of Civil Procedure. One important distinction for our purpose is that it is unnecessary under the Massachusetts version of Rule 8 to allege the basis for subject matter jurisdiction. Compare Federal Rules of Civil Procedure 8A1. We will also want to assert our right to a jury trial. See Massachusetts Rules of Civil Procedure 38B. Identical in relevant part to Federal Rules of Civil Procedure 38B. Oh, the associate's response to Philip Slater from David E. Howard complaint in Schulansky v. Ronan, our file number 041248, December 1st, 2004. I have attached a draft complaint and summons in the Schulansky matter. Please note that I have made both Richard Ronan and Ronan Construction defendants in the suit. I refer to them collectively as Ronan in this memo. The contract was signed by Richard Ronan, but on the stationery of Ronan Construction Company. At this stage, it is not clear whether Ronan signed on behalf of the corporation or individually or both. Since either or both may be liable, I have named both as defendants. As my draft complaint indicates, Schulansky may be entitled to relief on two separate theories: breach of contract and negligence. Ronan may have breached the contract in several ways. First, Ronan may have agreed to reconstruct the foundation if necessary, but failed to do so. The proposal estimate is hardly clear on this. The only relevant provision is paragraph 2, which requires construction of foundation walls to support the 18-foot by 25-foot addition. However, an argument can be made that the old foundation wall at the juncture of the house and the addition is part of the foundation of the addition, and therefore the contractor had a duty to make sure that that part of the foundation was solid as well. Paragraphs 23 and 24 of the draft complaint assert this basis for recovery for breach of contract. Our argument that paragraph 2 require Ronan to construct the foundation is bolstered by the negotiations between Ronan and Schulansky concerning possible reconstruction of the foundation if it turned out to be inadequate. The potential problem here is that these discussions took place before the proposal and estimate were signed. The defendants will no doubt argue that the written contract embodies the entire agreement between the parties, that on its face it does not include an obligation to reconstruct the old foundation, and that the parole evidence rule bars evidence of prior negotiations to vary the terms of the contract. So generally, procedurally, volume or contract. Section 7.12, 1998. We will have to argue that paragraph 2 is ambiguous so that evidence of the prior negotiation is proper to demonstrate the intent of the parties. Alternatively, it may turn out that the settling resulted from damage to the foundation by Jones in the excavating of the cellar. If this is true, Ronan will still be liable for breach of contract theory. Certainly, an implied Term of contract between Ronan and Schulansky is that the work will be carried out in a careful manner, including the work that Ronan chooses to delegate to his employees or agents. See restatement, second of contract, section 318(3). Delegation of duties under contract does not discharge delegating party from the duty to perform those duties. Even if it was Jones who damaged the foundation with his backhoe, this would constitute a breach of Ronan's duties before the contract worked carefully. Thus, even if we cannot prove that Ronan had agreed to rebuild the foundation, this would constitute a separate breach of contract, which gives rise to the claim for whatever um, subsidence resulted from the damage. I have included this allegation in paragraph 25 of the draft. The second claim for relief in my draft complaint asserts a tort claim for negligence based on the allegation that the negligent excavation by Jones led to subsidence. If Jones acted as Ronan's employee in performing the excavation work, Ronan will be liable for Jones' negligent acts, since employees are liable for the torts of their employers in the scope of employment. Employees are liable for the torts of employees in the scope of employment. Restatement, second of agency, section 219. It is not clear at this stage whether Jones operated as an employee or independent subcontractor in performing the excavation work. The legal distinction between an employee and independent contractor turns on the employer's right to control the details of the work. Cowan v. Eastern Racing Association. See generally J. Clannon, the law towards examples and explanation. Restatement, second of agency, section 220. If Ronan exercised detailed control over Jones in the matter of digging a new cellar, Jones acted as Ronan's employee. If Ronan would be liable for Jones' negligence. However, if Ronan simply hired Jones to complete the excavation work on his own for an agreed price, Jones may have acted as an independent contractor. There is some reason to believe that Jones acted as Ronan's employee, since according to Schulansky, Ronan appears to direct him in the course of the excavation work. Thus, I have drafted the second claim for relief on this theory. An important goal of discovery on our second claim for relief will be to ascertain the exact course of dealing between Ronan and Jones to determine whether Jones acted as Ronan's employee or as an independent contractor. Once you have reviewed the draft and made any changes, I will arrange for filing of the complaint and service under the defendants in New Hampshire. All right, so they have to serve in New Hampshire, they get personal jurisdiction, I guess. All right. Right. No, they live in New Hampshire. That's why they want to serve them. But they want to go to court. But they didn't decide to do diversity jurisdiction because they wanted to be in the state court. All right, so now we have the resulting document. We see it here. Yeah. Okay, let's read it. Plymouth County, Deborah Schulansky, plaintiff versus Richard L. Ronan, Ronan Construction Company. Complaint and demand for jury trial. Superior Court Civil Action over Plymouth County. Okay. The plaintiff, Deborah Schulansky, is an individual residing at 219 Parker Street, Plymouth County, Massachusetts. The defendant, Ronan Construction Company, is a corporation incorporated in New Hampshire with offices at 1124 Newark Road, Nashville, New Hampshire. The defendant, Richard L. Ronan, is an individual residing at 3 Charleston Drive, Nashville, New Hampshire, and the president of Ronan Construction Company. At all relevant times, defendant Richard L. Ronan acted as the authorized agent of Ronan Construction Company. Facts. The plaintiff owns an antique colonial house located at 53 School Street in Alton, New Hampshire. The house was built in 1782 and is listed in the National Register of Historic Places. In February 2004, the plaintiff met the defendant Richard L. Ronan while Ronan was working on a restoration project in Plymouth, Massachusetts. At that first meeting, Ronan represented to the plaintiff that he was experiencing a restoration of historic houses in New Hampshire and Massachusetts. In early March 2004, the plaintiff met with Ronan at her home in Plymouth, Massachusetts to discuss the possibility of hiring him to build an addition on her house in Alton, New Hampshire. During that meeting, the parties discussed the need for extensive rebuilding of the foundation of the main house adjacent to the planned addition. During that meeting, the defendant, Richard L. Ronan, agreed that any necessary reconstruction of the old foundation would be included as part of the construction of an adequate foundation for the addition. After the March meeting, Richard L. Ronan sent a proposal and estimate to the plaintiff in Plymouth, Massachusetts, describing the work to be done and offering to perform the work for $50,000. A copy of the proposal and estimate is attached to this complaint as Exhibit A. The plaintiff accepted the defendant's offer by signing the proposal and estimate and mailing it to the defendant at their office in Nashville, New Hampshire on April 3, 2004. The defendant commenced the work of the addition on April 15, 2004, and continued until June 3, 2004. In the course of work, the defendants or their agents excavated the earth from the outside of the foundation of the main house to a depth of approximately 7 feet. This excavation revealed that the base of the foundation consisted of loose rocks piled on top of each other and held in place by the surrounding earth. I'm sorry, both Schulansky and Ronan should have had a civil engineer or a foundation person come who knew what they were doing, because they would have known that this is a popular foundation in this area and that what would likely happen if it was to start. Like when I had my foundation redone, that's what happened. Like the foundation guy, and then he has a civil engineer that he works with who approves all his plans. He could tell me like in this area, what's under the earth is bare rock and this is how it's done. Like that's normal. So this is weird to me. But okay. Since she a friend, that's so much new. But let me get back for a minute. Okay. This commenced work on the addition on April 15, 2004 and continued until June 3, 2004. In the course of work, the defendants or their agents excavated the earth from the outside of the foundation of the main house to a depth of approximately 7 feet. This excavation revealed that the base of the foundation consisted of loose rocks piled on top of each other and held in place by surrounding earth. In the process of excavation, the defendants or their agents damaged the foundation of the main house by digging up and displacing large boulders which form part of the foundation. As a result of the removal of the supporting earth outside the foundation or the damage done to it during the excavation or both, it became necessary to reconstruct this part of the foundation to adequately support the main house and the addition. Despite their agreement to do so, the defendant failed to reconstruct the original foundation to provide adequate support for the house and the addition. Even after the plaintiff brought the problem to the defendant's attention during construction, he demanded that they reconstruct the foundation in accordance with their agreement. The defendant refused to do so. As a result of the inadequate foundation work, the main house and the addition have sustained age rating. I don't understand why she let him keep working at that point when he refused to fix it. She knew something was wrong. It's weird. And the addition has sustained major structural damage, including cracks in the walls and sagging of the first floor immediately above the affected area. First claim for relief, breach of contract. The plaintiff repeats and realleges the allegations in paragraph 1 through 20 of the complaint. The proposal estimate signed by the defendant, Richard L. Ronan, and the plaintiff constitute written contract for a valuable consideration between the defendants and the plaintiff. Under paragraph 2 of the contract, the defendants agreed to construct an adequate foundation to support the addition and adjacent portion of the main house. The defendants breached the contract by failing to perform their obligation to construct an adequate foundation for the addition. The defendants also breached contract by failing to perform the excavation work required by the contract in a careful manner, which resulted in damage of the existing foundation of the house. The plaintiff made all progress payments under the contract in a timely manner until she became aware of the defendant's breach. As a result of the defendant's breach, both the main house and the addition have sustained major structural damage, which will require extensive repair and reconstruction. Second claim for relief, negligence. The plaintiff repeats and realleges the allegation in paragraphs 1 through 20 of the complaint. In the course of the construction of the addition, the defendants or their employees negligently excavated the area adjacent to the foundation of the main house. As a result of this negligent excavation, the foundation of the main house was displaced and damaged, causing subsidence of the foundation and structural damage to the main house and the addition. Demand for relief. Wherefore, the plaintiff demands judgment in the amount of her actual damages plus interest and costs, and such other relief as the court finds just and equitable. Demand for jury trial. Pursuant to Massachusetts Rules of Civil Procedure 38, Section B, the plaintiff demands jury trial of all issues triable of right by jury. Where the plaintiff demands judgment in the amount of her actual damages plus interest and costs, and such other relief as the court finds just and equitable. So they are, yeah, they are like, hey, it's a little long, but if you think we should have more, give us that too. And this is signed by Phyllis Slater, Gomez Robinson Slater, attorney for the plaintiff in Plymouth, Massachusetts. So I assume the reason that she needs to be with David is because they're filing in New Hampshire, and she is a Massachusetts attorney, so she has to have an associate to file it in the state that she wants to file it in. Yeah, she got a New Hampshire attorney. No, I'm sorry. No, she's a Massachusetts attorney, and she's filing in Massachusetts. I'm not sure. Plymouth County, Massachusetts. Yeah, I'm not sure where Ms. David Howard is, if he's in her own office or in New Hampshire guy. I'm not sure. Okay. Super A. See, this is the contract that was signed between Roman and Schulansky. So let's see what it says. Roman Construction, 1124 Newark Road, Nashville, New Hampshire, 03061. This is Exhibit A. And then there's to Deborah Schulansky, her address regarding addition to premises at 53 School Road, Austin, Massachusetts. The date of this proposal was March 18, 2004. Excavate 18 foot by 25 foot by 7 foot deep area at the right of the house, remove fill. Construct footing, cellar floor, and foundation walls to support 18 foot by 25 foot addition. Cut doorway through the present foundation into new cellar. Construct one-story addition with peak roof and unfinished added cross base. Standard frame construction, including cedar, clapboarding, siding, and asphalt shingle roof. 2 standard double hung windows, each side west and east, and 2 6-foot bay windows, double glazed, on the main south wall. Interior wall, standard drywall construction, clear maple finish, and baseboards. Remove wall where addition abuts house. Support upper floors with steel beams, spanning, opening. Clean up the side roof, clearing out shooting or planting. Electrical work to be done by separate contractor hired by owner. Contractor reserve the right to subcontract excavating and concrete work. So he reserves the right, but it doesn't say if he does. Work to be completed by June 20th, 2004. Estimated cost $50,000, $6,000 on completion of excavation, $6,000 on completion of foundation, $10,000 on completion of framing, $10,000 on completion of exterior finish work. So far, and then balance the completion of the job. So far he's gotten $32,000. So what's remaining is $18,000 that he has not been paid. Okay, so now we have this here, which is the summons. Take a look at the summons. The summons. Okay, let me read it. It says, Commonwealth of Massachusetts Superior Court Department of the Trial Court of the Commonwealth Civil Action Number, Plymouth. Okay. It says, Deborah Schulansky, plaintiffs, Richard O. Ronan and Ronan Construction Company, defendant summons. To the above named defendant, you are hereby summoned and required to serve upon Phyllis Slater, Gomez, Robbins, and Slater, plaintiff attorney, whose address is 322 Puritan Road, Plymouth, Massachusetts, and answer to the complaint, which herewith is served upon you within 20 days after service of this summons upon you, exclusive of the day of service. If you fail to do so, judgment by default will likely be taken against you for the relief demanded in the complaint. You are also required to file your answer to the complaint in the office of the clerk of this court at Plymouth, either before service upon plaintiff attorney, within a reasonable time frame. Unless otherwise provided by Rule 13A, your answer must state as a counterclaim any claim which you have against the plaintiff, which arises out of the transactional occurrence that is the subject matter of the plaintiff claim, or you will thereafter be barred from making such claim or other action. Witness Barbara J. Ross, Esquire, at Plymouth, the 8th day of December in the year of our Lord 2004. All right, and signed by the clerk, whatever that means. Notes, the summons is issued pursuant to Rule 4 of the Massachusetts Rules of Civil Procedure. Number 2, when more than one defendant is involved, the names of all defendants should appear in the caption. If separate summons is used for each defendant, it should be addressed to the particular defendant. To the plaintiff's attorneys, please circle the type of action involved: tort, motor vehicle, tort, contract for equitable relief. Proof of service of process, I hereby certify and return that on blank 2000 blank, I served a copy of the within summons together with a copy of the complaint in this action upon the written name defendant and the following manner. service on defendant in this box on the original and on the copy served on defendant. All right, that's some writing here on the side of the page. Let's take a look at what that says. It says, notice to defendant, you need not appear personally in court to answer the complaint, but you can claim to have a defense. Either you or your attorney must serve a copy of your written answer within 20 days specified herein, and also file the original in the clerk's office at 20 days to respond to the complaint. Comments on the Schulansky complaint. Let's see what the comments are, and then comments on the summary. Okay. Comments on the Schulansky complaint. Just making sure we're still recording. Although Schulansky complaint has been drafted to comply with the pleading requirements of the Massachusetts Rules of Civil Procedure, Massachusetts Rules of Civil Procedure 8 through 11, these rules are very similar to 8 to 11 of the Federal Rules of Civil Procedure. The following comments keyed to the numbers to the left of the complaint therefore refer to the rules generically, unless the federal and state versions differ on the particular point under discussion. Okay, so it'll just have the rules of civil procedure. It won't say Massachusetts or federal unless the sections are different, because a lot of the states rules of civil procedure model the United States. So you'll find the same information in the same section. I believe that's what this means. So while some contents of pleadings are a matter of custom in a particular court or personal preference of the drafting attorney, the rules specifically govern many aspects of pleading. For example, Rule 10A requires every pleading to have a caption such as that in the Schulansky complaint. Under Rule 10A, the caption must include the name of the court, Commonwealth of Massachusetts, Plymouth County Superior Court Department. The docket number of the action, civil action number, the names of the parties, and the designation of the pleading, complaint, and demand for jury trial. The docket number is a number assigned to each case by the court clerk for administrative purposes. On Schulansky's complaint, the docket number is left blank because the case will not be assigned a docket number until the complaint is filed with the clerk. Note that Howard has included a number of subheadings in the complaint. While these are not required by the rules, such subheadings are frequently included for the sake of clarity, particularly in a lengthy complaint that asserts a number of claims or where the factual allegations are complex. Separate sections of the parties' facts and claims for relief make it easy for the court and parties to quickly find and review parts of the complaint during motion arguments or other proceedings. In federal actions, the jurisdiction subheading is frequently added because federal rules of civil procedure 8A1 specifically require the plaintiff to allege the basis for subject matter jurisdiction over the act. In federal actions, jurisdiction subheading is frequently added because federal rules of civil procedure 8A1 specifically requires the plaintiff to allege the basis for subject matter jurisdiction over the action. Such an allegation is not required under Massachusetts Rule 8 because, unlike the federal district courts, the Superior Court is a court of general jurisdiction. For many simple cases, such as an action on a note or a straightforward motor vehicle tort case, the complaint may be so brief that subheadings are unnecessary. The appendix of forms accompanying the Federal Rules of Civil Procedure, Forms 318, for examples of such complaints. The federal rules do not explicitly require separate paragraphs identifying the parties to the action. However, it is customary to begin the complaint with descriptions of the plaintiffs and defendants. This information is important to various issues, including personal jurisdiction. This information is important to various issues, including personal jurisdiction, venue, capacity to sue and to be sued, and particularly in federal diversity action, subject matter jurisdiction. Okay, so there's not separate paragraph. See, they put it in separate paragraph, the parties, you see that? But it doesn't have to be that way. That's not a requirement. Right, that's what it said. federal rules do not explicitly require separate paragraphs identifying the parties in the action. The Massachusetts rules do, however, require that the residence or place of business of the parties be specified. However, the Massachusetts rules do, however, require that the residence or place of business of the parties be specified. Massachusetts Rules Civil Procedure 10B. So the federal rules don't require it, but the Massachusetts rules do. And so since they filed in from Massachusetts, they followed the Massachusetts rule. Okay. Now, this information is important to various issues, including personal jurisdiction, venue, capacity to sue and be sued, and particularly in federal diversity action subject matter jurisdiction. In Schulansky complaint, for example, the allegation that Schulansky resides in Plymouth County indicates the plaintiff's business under state law for laying venue there. Maybe complaint will include a subheading entitled Facts or Factual Allegations, setting forth a brief description of the events that give rise to the plaintiff's claim for relief. This type of breakdown is useful, particularly in complex cases, to distinguish the underlying facts giving rise to the claim from the plaintiff's asserted claims arising out of those facts. So they separate facts or factual allegations, setting forth a brief description of the events that gave rise to the plaintiff's claim for relief. This type of breakdown is useful, particularly in complex cases, to distinguish the underlying facts giving rise to the claim from the plaintiff's asserted claims arising out of those facts. In the Schulansky case, for example, there is enough factual background that a separate facts section facilitates a fair understanding of the claims. It is true that Rule 8A2 only requires a short, plain statement of the claim, and that very brief general allegations will suffice to avoid dismissal. But a little more detail than the minimum required by pleading rules will give the court a clearer picture in the case from the plaintiff's point of view. And since Rule AB requires the defendant to respond paragraph by paragraph to the allegations in the complaint, a more detailed complaint will elicit more specific denials or admissions in the defendant's answer. The rules require all allegations in the body of the complaint to be set forth in numbered paragraphs. Rule 10B. This facilitates quick reference to the allegations in the complaint. It also allows defendants to respond to each of the plaintiff's allegation by number, and allows the plaintiff to incorporate allegations by number in later parts of the complaint, as Howard has done in paragraphs 21 and 28 of the Schulansky complaint. Rule 10B also provides that the allegations in each paragraph of the complaint shall be limited as far as practical to a statement of a single set of circumstances. However, reducing specificity at the atomic level, for example, by breaking Schulansky's paragraph 5 into 3 paragraphs, will make the complaint unduly tedious. The allegations in paragraph 5 all relate closely to the issue of the age and value of the house and form a logical grouping for a single paragraph. The rule does not limit each paragraph to a single fact, but to a single set of circumstances, and calls for a common sense breakdown of allegations as far as practicable. I wonder why there's practical instead of practical. Okay, so here are the facts. What are your first choices? Okay, for example, by breaking Schulansky's paragraph 5 into 3 paragraphs. Paragraph 5. Paragraph 5 says, the plaintiff owns an antique colonial house located at 53 School Street in Altoona, New Hampshire. The house was built in 1762 and is listed in the National Register of Historic Places. So I guess you could split it into 3. You can say the plaintiff owns an antique colonial house located at 53 School Street. You can say the house was built in 1782, and then you could say it's listed on the National Register of Historic Places. So that's how that would be. Okay. Oh, sorry, I'm sleepy. Okay. 6. The rules authorize parties to attach exhibits to their pleadings, as Schulansky has done here. 10C, parties should exercise care in incorporating documents in the complaint. However, since doing so may constitute an admission, at least in the authenticity of the documents, if not their accuracy. Here, for example, Schulansky's incision of the proposal and estimate, together with her allegation that it constitutes the contract between her and Ronan, may weaken her argument that Ronan had additional duty arising out of their prior discussions to repair the foundation. See the third defense in Ronan's answer, page 607. In paragraph 21 through 27 and 28 through 30, Howard has recast the factual allegations in terms of claims for relief for breach of contract, that the facts alleged satisfy the elements of legally recognized claim that, if proved, entitled Schulansky to relief. The subheading claims for relief tracks the language of Rule 8A2, which requires the complaint to include a short and plain statement of the claim showing that the pleader is entitled to relief. Here, Schulansky has asserted a right to relief under two distinct theories. If the court concludes that she has proved a right to discovery on either her contract theory or her tort theory, it will grant her whatever relief is popular under that claim. This pleading in the alternative is expressly authorized by Rule 8E2. If the court concludes that she has proved a right to recovery on either her contract theory or her tort theory, it will grant her whatever relief is proper under the claim. Okay, the rules do not require the pleader to state the legal theory on which he claims a right to relief. A brief description of the claim, that is, the events giving rise to the action, is sufficient. See Burdenthal, Kane, and Miller, section 5.7. However, it is certainly appropriate and helpful to allege the elements of each claim clearly, especially in cases involving multiple theories of relief based on the same underlying facts. We no longer insist upon technical rules of pleading, but it will be difficult in a jury trial to segregate issues which counsel do not separate in their pleading, preparation, or thinking. Separate pleading theories are often labeled as different counts instead of claims for relief. In simple complaints, such subdivisions are unnecessary. See, e.g., Appendix of Forms accompanying Federal Rules of Civil Procedure, Form 17, which asserts two theories of relief clearly without separate counts or subheadings. Students sometimes ask why Schulansky's counsel assert two theories of relief. If they have a viable claim for breach of contract, why take on extra burden of alleging and proving the negligence claim as well? Well, Schulansky's lawyer would do their client a serious disservice by omitting the negligence claim from their complaint. After all, they may not recover on the breach of contract claim. Perhaps they missed the limitations period, or the jury will find that Schulansky had waived the rebuilding of the foundation, or for some reason the contract theory may fall by the wayside. If so, Schulansky's counsel will clearly want to preserve their options by asserting any other viable theories of release based on the defendant's conduct. And indeed, they would likely be liable for more practice if they put all their eggs in one basket. Schulansky, or the footnote, Schulansky might have other claims for relief in addition to the two asserted in the complaint. For example, other claims might be based on the failure of Ronan to properly supervise Jones or negligent selection of Jones as subcontractor. For illustration purposes, however, I tried to keep the complaint to a manageable one. All right, so there were others. Practice if they put all their eggs in one basket by leaving out a viable negligence claim unrelated to losing the contract claim. Clients expect their lawyers to assert all supportable rights they have, not pick and choose among them based on what they think has the best chance of success. Thus, lawyers feel considerable pressure to include any supportable theory of recovery in their complaints. Better to assert it and lose on it rather than leave it out and explain to the client why they abandoned a claim that might have provided her some relief. At the same time, lawyers are under considerable pressure under Rule 11 of the Rules of Civil Procedure not to assert theories for which they lack support. See Note 11 below. Such conflicting pressure, among other things, make a litigator's life interesting. Okay, Rule 10C authorizes a pleader to incorporate prior allegations by reference in later parts of the pleading. However, Howard has done so in order to make clear that the breach of contract claim is based on the facts alleged in the cited paragraphs. At the end of the complaint, Howard concludes the demand for relief Schulansky seeks on both claims as required by Rule 8A3. In this case, the relief is sought in damages, but in other actions, different types of relief are also commonly sought, such as specific performance, an injunction, a divorce, or a declaration of the rights of parties. Attorneys differ as to whether to put a demand for relief after each claim for relief or to place a single demand at the end of the complaint. Clearly, if the relief requested differs on different claims, separate demands for relief are appropriate. For example, if Schulansky were seeking specific performance of the contract with Ronan, inserting separate demands for relief after each claim for relief would help to make it clear that specific performance is sought under the contract claim rather than the negligence claim, which would not support a demand for specific performance. Because she seeks only damages on each claim, however, and the measure of damages in each theory is apparently the same, either a single demand at the end of the complaint or demands after each claim would be appropriate. Compare the separate demands for relief in Ronan's third-party complaint. Note that the demand for relief in the Schulansky complaint does not state a specific dollar amount requested. This is because Massachusetts statutes bars plaintiff from stating a specific dollar amount. Massachusetts General Legislative Chapter 231, Section 13B. Several states have enacted such statutes to avoid adverse publicity and possible jury prejudice from inflated damage figures in the pleadings. 10. Rule 38B provides that a demand for jury trial may be endorsed upon a pleading, which means in plain English that it may be asserted in the complaint or answer, because the right to trial by jury is waived if not demanded within 10 days of the close of the pleading. See Rule 38B. It is wise to insert the demand for jury trial in the complaint, otherwise plaintiff counsel may forget about it, and the period for seeking jury trial may slip by a notice. Okay, now let's go to Section 11 that we were told to read before. So 11, Rule 11 governs signature of the complaint and other pleadings. 3, the complaint is shown here with the attorney's signature affixed. Subsequent plaintiffs and motions have not been signed because they are suggested pleadings for the partner's review and have not yet been filed in court. All right, so the rule also imposes important ethical duties on attorneys who sign complaints and other court papers. Under Federal 11, an attorney's signature on a complaint certifies to the court that the attorney believes, after reasonable inquiry, that the factual allegations of the complaint have evidentiary support, or for specifically identified allegations are likely to have evidentiary support after a reasonable opportunity for further investigation or discovery. The attorney's signature also certifies the legal positions taken in the complaint. In the Schulansky case, for example, that the plaintiff has the right to sue for breach of contract, or that Ronan's liable for the acts of Jones are warranted by existing law or by a non-frivolous argument for the extension, modification, or reversal of existing law or the establishment of new law. Rule 11B2, last, the signing attorney certifies that the pleading or motion is not filed for any improper purpose. The reasonable inquiry requirement was added to Federal Rule 11 in 1983 to strengthen the attorney's obligation to the court to avoid frivolous or unethical pleadings. The language does not require Slater and Howard to complete their research or investigation before filing suit against Ronan, but it does require them to have a factual basis beyond mere opinion or speculation to support the pleaded facts, as well as a colorable argument for the legal positions asserted in the complaint. The factual standard of Rule 11 would be met by the information Schulansky gave her attorneys about the construction problem before they the factual standard of Rule 11 would be met by the information Schulansky gave her attorney about the construction problems before they drafted the complaint. They knew that the damage appeared shortly after the construction work began in an area where the work was being done. They also knew that an engineer had viewed the damage and concluded that it resulted from the inadequate construction work. This provides evidentiary support for the factual allegations in the Schulansky complaint. The rule does not require certain or admissible evidence in this early stage of the suit, only a reasonable pre-filing inquiry. Certainty or admissible evidence not required. The legal standard of Rule 11 will also be satisfied in the Schulansky case. Howard and Slater had a copy of the contract which required Ronan to construct walls to support the addition. If the damage to the house resulted from inadequate support, they would arguably constitute a breach of contract. In addition, the discussions between Ronan and Schulansky during the negotiation may well support a claim that Ronan had agreed to reinforce or rebuild the foundation. Similarly, if the engineer's alternative conclusion that the backhoe damaged the foundation is accurate, that would certainly constitute actionable negligence. Interestingly, the pleading requirements in Massachusetts Rule 11 are less stringent than those in Federal Rule 11. Under Massachusetts Rule 11, the attorney's signature certifies that to the best of his knowledge, information, and belief, there is good ground support the pleading, and that is not interposed. Okay. Under Massachusetts Rule 11, the attorney's signature certifies that to the best of his knowledge, information, and belief, there are good grounds to support the pleading and that it is not interspersed for delay. It does not impose requirements of pre-filing inquiry and does not make reference to improper purposes other than delay, as for example, escalating the expense of litigation to the point where the opponent cannot sustain it. In addition, the Massachusetts version only authorized sanction for willful violations. The Massachusetts rulemakers have been unwilling to impose the stricter requirements of Federal Rule 11. Consequently, sanctions for improper pleading are invoked less frequently in Massachusetts state courts than in federal courts. Okay, okay, sanctions for willful violations and sanctions for improper pleading are invoked less frequently. Okay. Comment on the summons. Rule 4 requires both summons and complaint to be served on the defendant. The complaint is written by the plaintiff or his attorney, setting out allegations against the defendant. The summons, by contrast, is an official order from the court requiring the defendant to respond to the complaint. Hence, Rule 4 requires the summons bear the seal of the court and be signed by the clerk. Rule 4 requires both the summons and complaint to be served on the defendant. The complaint is written by the plaintiff or his attorney, setting out the allegations against the defendant. The summons, by contrast, is an official order from the court requiring the defendant to respond to the complaint. Hence, Rule 4 requires the summons bear the seal of the court and be signed by the clerk. In other courts, printed summons, like the one used here, already signed and sealed, may be obtained in blank from the clerk's office. The plaintiff attorney fills out the blanks and arranges for servants of the summons with the complaint. Compare the printed summons with the detailed requirements of Federal Rule 4A, Massachusetts Rule Civil Procedure 4B. Both parallels Federal Rule 4A. The summons includes the seal of the court. The court seal is embossed on the Schulansky summons, but it does not show up in the reproduction. The name of the court, okay. The name of the court, space for the names of the parties, and name and address of the plaintiff's attorney. It also warns the defendant, as required by Massachusetts Rule 4B, that he must answer within 20 days or default judgment will be entered against him. See Rule 55, which authorizes entry of a default judgment if the defendant fails to respond to a claim. The first paragraph of the summons quite properly distinguishes between service and filing of the defendant's answer. Rule 12A requires the defendant to serve his answer to the plaintiff within 20 days of the service of the complaint. See Chapter 17 for a discussion of methods of service of process. As the summons states, the answer must be filed with the court before it is served, or within a reasonable time thereafter. Nothing in Rule 4B requires inclusion of a second paragraph of the summons, warning defendants that they must assert compulsory counterclaims under Rule 13A. The purpose of the warning is obviously to remind defendants who must respond within a short time that they must assert any compulsory counterclaims in their answer or risk loss of those claims. The printed summons usually includes space here at the bottom of the page for the sheriff, constable, or other process service to provide proof of service. See Federal Rule 4.1. The server fills out the form indicating the date and manner in which the service was made and files it with the court. If service is made directly by the plaintiff's attorney, for example, in a case such as this one, where service on the out-of-state defendant will likely be made by mail, a separate sworn affidavit must be filed setting forth the time and manner in which the service was made. If service is made directly by the plaintiff's attorney, for example, in a case such as this one, where service, for example, in a case such as this one, where service of an out-of-state defendant will likely be made by mail, a separate sworn affidavit must be filed setting forth the time and manner in which the service was made. Federal Rule 4.1. Oh, instead of using the processor. The printed summons usually includes space here at the bottom of the page for the sheriff, constable, or other process service to provide proof of service. See Federal Rule 4.1. The service goes at the bottom form indicating the date and manner in which the service is made by the court. That's what they do, constable, or other process service. But if it's just the plaintiff's attorney who does it by mail, a separate sworn affidavit must be filed, setting forth the time and manner to which the service is made. Federal Rule 4. Okay. All right, so we have 2930 now. 31 is actually a change of form. Ronan removes the federal court in those documents. And then we have the defendant's answer for Ronan and the resulting documents. And the counterclaim chain reaction. Ronan brings in Jones. Jones seeks the way out. Tactical dilemma. Ronan's motion for summary judgment. Okay, so to finish this, we need to read from 589 to page 666, which is the last page of the book. So that is going to be 77 pages. So we're going to divide this up over the next 3 weeks, and that help us to totally understand pleadings and what the court is about. So yeah, so that's what we're going to be doing for the next 3 weeks, apparently, to understand pleadings and civil procedure. Yeah, it reads fast though. So anyway, so join us for the next 3 weeks as we read about the rules in action as we read the Schulansky Case. Thank you so much for tuning in today's episode of Legally Not Read, Legally Raven here.